Hello and a very warm welcome to you. It is 2020, the year of perfection, and I welcome you to your #1 legal talk show. Yes, our man of God, the president and founder of Love Word Incorporated, recognized the courthouse as one of the major talk shows of the year 2019, and that is thanks to you. And you sincerely became the sports commentator, so social affairs presenter of the year 2019. So I say thank you, love applause, and thank you to my man of God, Pastor Chris Oyahilome. But this is a courthouse, and we talk about the law and all the legal jargons. We'll be right back. You're welcome back. If you just joined us, this is the courthouse, and I'm Itohan Olomu-Agbodo. And this week on the show, we are going to be reviewing a lot of issues in the Nigerian judiciary in the past decade. There are some high points that I want to focus on this first episode in this first season of the year 2020. And I'm joined by a distinguished senior advocate of Nigeria, and he is none other than Godwin Omoaka. It's a pleasure to have you here, sir.
It's a pleasure to be here, as always.
Okay, so my learned silk, you'll be talking about the judiciary. And let me first of all start by asking you, what is the major, for you, one of the major challenges in the year 2019 and of course the past decade for the Nigerian judiciary?
Well, I think the major challenge for me will be that the Nigerian judiciary has never had it this bad under this government. There has been clear attempts to interfere with the independence of the judiciary, and that is very disconcerting. Okay. Because the judiciary, under the doctrine of separation of powers, which is encapsulated in our constitution, is supposed to be an independent arm of government.
Of government, yeah.
That's why you have Section 4, which vests the Section 5 and 6 as well. 4 vests the executive powers
and 5 for legislature, and
for legislature, 6 for the judiciary.
Yeah.
Now, but what we have seen under this regime, under this government in particular, is an attempt to stifle the independence of the judiciary so that the judiciary functions at the whims and caprices of the government. And that is very sad. It's very sad because financial autonomy has not been granted to the judiciary. Judges have been put in a situation where they are compromised because of fear of the government of the day. I give you a good instance. Look at the way the former Chief Justice of Nigeria, Justice S.A.N, was removed with impunity and without due process. That process was a complete charade for any discerning legal mind. The Code of Conduct Tribunal has not the jurisdiction. And then there were orders from about 4 high courts to say, don't proceed with this matter. All right? But the government will not listen because they were hell-bent on getting him out and replacing him there with somebody else. So the truth of the matter is that the independence of the judiciary has been compromised by this government in particular. Secondly, we have seen cases of disobedience of court orders, willful and flagrant disobedience of court orders. That is very bad in itself. It has cast our image in the international community in a very bad light. Yeah. In fact, the recent release of Omoyole Sowore and Ibrahim Dasuki was because of the interference of the international community, specifically the United States government, who had to make a phone call to Attorney General to say, I mean, what is happening? And then you saw the statement, I'm sure you saw the statement that was signed by members of Congress of the United States, where they really castigated the Nigerian government and criticized actions of government. So you cannot continue to disobey court orders. Unfortunately, the court cannot enforce its own orders. it is the executive that will
That will have to
enforce those
enforce.
orders. And when
So,
the executive disobey the court orders, then you begin to ask yourself, where are we? So for me, these are the major factors that have affected the judiciary over the past decade, and in particularly last year. I think these two issues are very critical.
Okay, quite interesting. Like you said, these were the basic foundations of the legal system in Nigeria generally in 2019 and indeed the past decade, because we saw a lot of disobedience of court orders, like you said. But when does the Attorney General have to wade in? Because eventually the Attorney General said he was taking over the case of Showore, for instance, and going to start over prosecution all over again. So what, in your opinion, was it early enough? Was that supposed to have been the right action at that time?
So let us be clear, right? That was a ruse sold to the Nigerian public to hoodwink and deceive. Omoaka all along was being prosecuted by the Attorney General, who gave a fiat to Mr. Liman, Senior Advocate of Nigeria, to undertake the prosecution on his behalf. So it was the Attorney General who was undertaking the prosecution. You get the point? So there was never a time when he was not
in the picture.
In the picture. He was the one prosecuting. As you're aware, the Attorney General under the Constitution can give fiats to private individuals, private citizens, legal practitioners to prosecute matters on his behalf. And that was exactly what happened in this case. So when the various court orders came for the release of Omoaka and Dasuki, then the Attorney General came up with this very bizarre and very curious statement that he was taking over. No, he was not taking over, all right? If he chooses to prosecute directly from his office, that is not the same as taking over as envisaged under the Constitution. You know, so it was a ruse that was sold to the public, and for those who were not following events, who did not understand what was going on, unfortunately, a lot of people fell for it. But that is not the correct situation, and that will not actually happen. And then he couldn't have directed the release of Showore and Dasuki. Again, that statement was false, which he put in the public space. What happened is that the courts had already ordered their release.
Okay.
You had, for Dasuki, you had more than 7 courts. The High Courts, the ECOWAS Court, the Court of Appeal, ordering his release on bail, and even awarding damages against the federal government. The same for Omoaka. So what the Attorney General simply did was to comply
with the court's directive.
with the court directive. So for him to say he has directed the release of, I mean, I think that was clearly wrong, and it was intended to be mischievous.
Okay, that's quite interesting, because we've seen a lot of mischievous happenings in recent time, and especially in the last decade. So now looking at this judiciary, by way of actually moving forward in this new decade that we've just entered into, we have the fact that the judiciary will make rulings and orders and directives and generally just tell people what to do. But those directives have to be taken out by the executive. Now, this is a marriage that has come to stay. How does the judiciary extricate himself from such a situation where their orders are being disobeyed? How can the judiciary enforce its orders, as in actually make its orders to be complied with?
Unfortunately, there's so much the judiciary can do beyond making those orders. The judiciary cannot itself enforce those orders. Because you see, don't forget again, it still goes back to the issue of separation of powers. You know, the government is entrusted with executive powers. The police, who are the enforcing authorities, are under the control of the executive. So beyond giving those orders, there's really nothing the courts can do. And that is where the rule of law is imperiled. Because as an executive arm of government, you are supposed to give life to the Constitution. And you are supposed to ensure that no man is above the law. And you're supposed to ensure that court orders are enforced and obeyed. When you, who is an embodiment, the very representative of that institution that is supposed to carry out these functions, begin to flout court orders, begin to disobey court orders, then anarchy will reign. It means that everybody can disobey court orders. And that's why you see the international community had to step in. I think beyond the legal community rising in defense of the court, beyond civil societies rising up to speak on behalf of the rule of law, I think government should begin to rethink its responsibilities and begin to say, look, we need to obey the rule of law. We need to keep ourselves within the strict bounds of the rule of law. Otherwise, a situation of anarchy and complete lawlessness will prevail.
Okay, quite interesting. So you've been listening to Godwin Omoaka, a senior advocate of Nigeria. It's a privilege to actually have him here on the show. And we want to take a listen to this report on the judiciary in the past decade, and of course, when Attorney General should interfere in proceedings. And of course, we have some legal nuggets for your pleasure. Stay tuned. The Constitution of Nigeria guarantees the independence of the judiciary. The powers vested in the judiciary are provided for in Section 6, Subsection 6b of the 1999 Constitution, and it extends to all matters between persons or government or authority and to any person in Nigeria and to all actions and proceedings relating thereto, for the determination of any question as to the civil rights and obligations of that person. The Supreme Court is the apex court of the land and is presided over by the Chief Justice and has up to 15 justices. It is the final court of appeal. The challenges that faced the Nigerian judiciary in the last decade disabled it from fairly and efficiently dispensing justice. Some of these challenges and problems include judicial corruption, intimidation and manipulation of judges, delays, inadequate funding and infrastructure. These problems require urgent attention in order to restore sanctity of the Nigerian justice system. The constitutional provisions designed to guarantee judicial independence are in and of themselves ultimately inadequate to ensure both personal and institutional independence of the judiciary. There is need to do more to shield and protect judges from the imperious grip of politicians and elected officials. These necessary changes will help secure the right to fair trial and bolster public confidence in the justice system. You're welcome back. If you just joined us, this is the courthouse, and of course, we are reviewing the activities of the judiciary in the past decade, and our focus is on the Nigerian judiciary. And we still have Godwin Omoaka, S.A.N, with us, and he's been talking about his own perception of how the judiciary has actually been affected by some issues of the executive and things like that. But now, you said that apart from the civil societies coming out to protest and say, oh, comply with these orders of the court and all that, the judiciary can really not do so much, cannot go on and enforce its own decisions and all that. So can you give us some way forward? How do you feel that the judiciary itself can begin to become more active? Can we begin to see judicial activism, for instance?
Well, I think there's so much that has to be said for the courage of our judges, to be honest with you. Because if you look at the history of the Nigerian judiciary and the kind of judges that we have produced, the Oputas of this world, the Eshos of this world, the Nnamanis of this world, the Nnameka-Agus of this world, these were judges who were activist judges on the bench. They were very bold, and they wrote judgments that were very telling that till today.
Sagacious judgments.
Thank you. You have said it. So I think there's something that has to be said for the courage of the judges. But again, to be honest, I wouldn't put the blame on them. A situation where judges stay in their houses in the night and then they are invaded with full Viet armies, with full force of law, with security men. I mean, what do you expect the judges to do? So I think what we can see is judges coming out, maybe in their judgments, to speak against disobedience of court orders.
Okay.
I recall I was at the Supreme Court, I think on the 24th or 23rd of September, during the swearing in of the new senior advocates of Nigeria, where the CJN, the Chief Justice of Nigeria, my Lord, the Honorable Justice I.T. Mohammed, made a very clear statement that the judiciary was not going to tolerate disobedience of its orders. And then the question I asked myself when I read that was, but how are they going to do this? Do you understand? So I think that's where the issue of the independence of the judiciary becomes very, very critical. In the sense that when you say a judiciary whose appointment, a judge whose appointment, whose removal from office is on the recommendation of the NJC, the president now forwards the name to the Senate. I think we should cut out the executive in this business.
Okay.
I think my suggestion would be a constitutional amendment whereby once the NJC recommends any judge for appointment or removal, it goes straight to the National Assembly. And I would say in this case, National Assembly in the sense that both the House of Reps and the Senate, they have judiciary committees. They could have what they call a pre-confirmation hearing. Both judicial committees can come together to hear a pre-confirmation hearing, and after that, a proper confirmation hearing at the Senate, the way we have now. Otherwise, the executive arm of government will continue to interfere. Let's be honest, it's not a problem that started with this government. It's been there all along. But the intensity, of this government, this government have, become well known for disobedience of court orders. And so that is very, very disappointing. So for me, I think judges can be more activists. But again, I was at a conference recently when a judge said, how do you fight the government? They employ you, they pay your salaries. And so how?
He who pays the piper dictates the tune.
And that's why, again, we talk about financial autonomy for the judiciary. It's very important. There's already that in Section 83 of the Constitution, Section 212 of the Constitution, Section 169, I believe, of the Constitution, that guarantees financial autonomy for the judiciary. Again, the executive is not implementing that. So until the judiciary is able to be truly independent in the strict sense of the word, I'm afraid we will continue to move in cycles. So it is for the judges, as you know, judges cannot come out and speak. They cannot come out and fight for their rights. Okay, so it is for us.
Yes, I was going to say, so what about the role of the Nigerian Bar Association?
Yes, so it is for the NBA, the legal community, and civil society, and the whole Nigerian society to rise up in defense of the judiciary, because the judiciary cannot do it themselves. So this is where I know the president of the NBA has issued several statements on behalf of the judiciary to criticize government for the various decisions that they have taken. I've personally seen a lot of those statements. I've read a lot of them, but I think it goes beyond issuing statements. I think the judiciary has to mobilize itself. The NBA has to mobilize itself. Unfortunately, this is not the best of times for the NBA itself. It has its own internal issues and crises. As we know, the NBA president is being tried as well. So there are a lot of issues with the NBA, but I think that's where the NBA come in. And then we need to put our acts together to take this battle to the government on behalf of the judiciary. Because don't forget, these judges are first and foremost lawyers. They're our colleagues. They were lawyers before they became judges.
Okay. So now we will have to now think of how to strengthen the relationship between the bar and the bench.
Absolutely.
Okay, so now in actually going forward again, you've actually made some very profound suggestions that, if taken seriously, would actually help our judiciary. So how do you see the judiciary performing, leaving aside, or let me just ask simply, what other reforms would you like to see in our judicial system?
Some of the reforms I would like to see is, first and foremost, an expedited system of hearing. We're already working towards that, but it is not there. We're not there at the moment.
What about the front loading? It's not as effective as it should be.
Yeah, it's not as effective because, again, don't forget that no system works itself. Human beings work the system. And when there are deficiencies from the human angle, then it will ultimately affect whatever internal processes or systems you have put in place. And that is what we find with the front-loading system and all of that. The point is this: lawyers do not respect. I'm one of the lawyers. we do not play strictly by the rules. So it's a collective responsibility for us to have an efficient and effective system of justice administration in this country. So I would clearly like to see a situation where lawyers, we change our attitude, we change our mindset, we change our thinking, we change our behavior, and we follow the rules. I'm happy that right now in the court system, I'm seeing a situation where cost is being awarded against lawyers personally for defaults. All right? So I think that is going to be a game changer. And not just any kind of cost, huge cost is being awarded against.
So if you waste the time of the court,
yes.
In fact,
I was 2 years ago, I was, before the now retired Justice, former Chief Judge of Lagos State, and I had a matter which was slated for trial. I got to court, and for some reason, I had to ask for an adjournment. And the judge awarded 250,000 naira cost against me. So once you begin to have that in play, then lawyers themselves will begin to buckle up. Then another thing I want to see is introduction of technology into the judicial system. A lot of our courts, as judges have still taken notes in longhand. Yeah. I am aware that there are provisions in the Evidence Act for electronic taking of notes and all of that. But we have to talk about the funding. It's more an issue of funding, making the funds available for the various heads of courts to be able to implement this system in their respective courts. I'm happy that at the Supreme Court level, a lot has been done. I mean, the whole system, electronic recording, electronic certification of records, recording at the Supreme Court, is fantastic. The Supreme Court is, if you go to the Supreme Court now, it's like one of the most modern courts in the world. And it's comparable to anything you will find in the world. And I think that's where we should be headed. You know, for the whole justice system, not only the Supreme Court, the Court of Appeal, the High Court, Federal High Court, the State High Court. I have seen half-hearted attempts, but I think it's a question of funding. The judiciary does not have the funds to do this. They go cap in hand, begging government for funds. Government withholds their funds. So once they comply with the provisions of the Constitution to fund the judiciary directly, then I think we will see a change in justice administration system in this country.
Quite interesting. And I know you've been learning a lot from this discussion. It's been interesting, really. We've been talking about how to reform the judiciary, especially the Nigerian judiciary in this new decade. And Godwin Omoaka, Senior Advocate of Nigeria, has given us some suggestions. He's talked about even talking about activism, talking about autonomy, financial autonomy of the judiciary. And of course, he talked about lawyers being awarded costs directly if they default or wantonly just ask for adjournments or try to prolong matters unnecessarily. And you've been here before. There's that segment where I would ask you for your favorite Latin maxim.
Oh, my favorite Latin maxim this time will be that I love the maxim, nemo dat non quod habet. It's a very common maxim, but it's a very fundamental maxim in the sense that you cannot put something
what you don't have.
You cannot give what you don't have, because that's part of the essence of the rule of law. So for me, that is a maxim I like a lot to say. Nemo dat non quod non habet. Okay. And don't forget that as lawyers now, we are
phasing out
Latinism. we are being encouraged to move away from Latinism to verbosity to English. But it's a fundamental principle of our jurisprudence.
Yeah, and it's actually fundamental in every respect of life. You cannot give what you do not have. I'm sticking with that, nemo dat quod non habet. And you get to find out more Latin maxims in our Bar Book segment. Stay with us. interesting discussion with the esteemed senior advocate of Nigeria, Godwin Omoaka. I want to say thank you for making our time to be here with us. And we would like to see more of you this season.
Thank you.
Okay, we would like to hear from you. You can use our hashtag, the courthouse, and hashtag Lover Plus on any of our social media handles. We would also like you to download our app, Lover Plus, and you can go to our website on www.loverplus.tv for any information you require. And we'd like to hear from you. Like I said, you can send your emails to info@loverplus.org and to comments to numbers showing on your screen now. We also want your questions to start coming in as our legal experts prepare to answer them. I am S.A.N. Olomu-Agbodo, and I say, don't just get mad, go get a lawyer. Bye for now.